Last order report goal. Oh, the order was not uploaded. That is why they are not here.
Yes.
Last order likha nai niki? Oh, order was not typed and uploaded. We'll type and upload the order. Then we will hear both sides. The last order ki asle etu? Etu likhi diba last order to. Etia last date or order asle when was the last type or upload not this regularly? মই অৰ্ডাৰটো নিদিলো নেকি দিছোতো ডেফিনেটলি মই কোন আছিলে সুধিবাচোন কোন আছিলে অৰ্ডাৰটো কোনে লৈছিলে দেই টাইপ কৰি দিবলৈ ক'বা অৰ্ডাৰটো হা টাইপ কৰি দিব ক'বা তাক অৰ্ডাৰটো কি কৰিলে অৰ্ডাৰটো নহয় এইটো সি টাইপ কৰি দিব লাগিছিল ন অৰ্ডাৰটো কি কৰিলে আপলোড নকৰিলে টাইপ নকৰিলে কি কৰিলে আকৌ এইবোৰ learned counsel Ms. R. Chaudhary.
SB Chaudhary.
SB Chaudhary is present for the appellant. The respondent is not represented. List this matter. This matter has already been heard. Full stop. The learned counsel for the appellant has come prepared with some judgments to be referred. Full stop. List this matter on data deduction. So, when do you want?
On Thursday, my lord.
Thursday, no, not on Thursday. It won't be possible. On Friday.
Yes.
On Friday. এইটো এতিয়া হেৰি ভেৰিফিকেশ্যন কৰা কেলে অৰ্ডাৰটো টাইপ নকৰিলে আপলোড নকৰিলে ভেৰিফিকেশ্যন কৰা এনে পেলাই থৈ দিলে এনেকে ডেট এটা দি দিলে এইটো বেয়া কথা হৈছে
Or else the application, if an IE had been filed, then your lordship would have taken. Okay. If an
You want to reply on this
no, your lordship,
judgment?
Your lordship, actually, this judgment has been placed, and there is no prayer in the remanding back the matter. And they have not filed an application also under Order 41, Rule 27, which they should have done at the time of pleadings.
Then I may be allowed to.
Now, at the time of hearing, they cannot come out. Because that would be like amounting to, after taking advantage of the facts, and now again.
No, this won't work.
And section 107, my lord.
This won't work.
Yeah, maybe my prayer was for setting aside for, and for my lord,
this judgment is not helping you. Why this judgment is not helping you? Because this judgment is already the evidence was rejected.
Rejected in that case, yes, my lord.
It was, there is a prayer and the prayer was rejected. Here you do not have a prayer at all.
But section 107, my lord, if here, my lord, your lordship has got.
This is not section 107.
No, my lord, here is CPC, my lord, here.
Order 41, Rule 27.
That is for order 41, Rule 27, my lord.
You helping me with section 107?
And 107 is maybe helping me.
Without prayer?
Here, our prayer may not be for remand, but your lordship may remand it, my lord.
You can give me an authority. I don't see any. I have put two questions. There is no prayer.
Prayer is not there.
No prayer to that you have new circumstances and you can adduce evidence that you have been reinstated. There is no prayer. And this you want to bring into evidence so that your case gets strengthened against the prayer for damages. So if you are reinstated, definitely there is a prayer in your prayer for damages can be made, definitely. So here, you are giving me one
But
judgment.
the appeal contains this, my lord, that regarding the evidence that the
No,
regarding
no,
his
there is
reinstatement
nothing,
and all.
not
I have
a,
also annexed the my lord
no, no, it is not
pamphlet
helping.
also.
It is not helping. There is no evidence relating to reinstatement.
That
And
was
there is nothing,
subsequently,
nothing in the, maybe your appeal may contain, but in the original suit, there is no
They did
evidence.
not place. my lord.
So, if the appeal contains, where is a prayer? There ought to have been a prayer. You cannot bring one new prayer.
Prayer is not there, my lord.
Yes.
But circumstances, but statement and all there, my lord. I have annexed the pamphlet also, my lord.
You have not prayed to amend.
Prayer, yes, my lord. Prayer is not.
So send back for prayer. No prayer has been made for remand.
Here, section
The
107
short point
says,
that arises for consideration in this appeal is whether the Board of Revenue was justified in declining to admit a certified copy. It was already
they
submitted.
have placed, but we have
Uh-huh.
not placed. my lord.
So this will not help.
This decision may not help, but 107, may I read, my lord, again, my lord?
Give
107.
me some authority.
Yes, subject to aforesaid, the appellate court shall have the same powers and shall perform as nearly as may be the same duties as are conferred and imposed by the code on courts.
then you see this.
Then I have placed
Then
this as evidence.
if I'm exercising the same power, then definitely I'll reject it. If I'm exercising the same power, because it is not in the because you have not made any prayer.
Prayer is.
Definitely I'll reject it. You have not annexed this as your reinstatement order.
I have stated, my lord, repeatedly I have stated in my.
But have you annexed any order of reinstatement?
I have not annexed, but I have stated. Repeatedly I have
So then,
stated. And I have
there's a
annexed the
good ground to
pamphlet, my
reject
lord.
it.
Pamphlet is annexed, my lord.
What pamphlet?
Pamphlet on the basis of which action was taken against the appellant, my lord. This is annexed.
That was given in the lower court also.
They were not exhibited. That was given, they were never
That is not
exhibited.
exhibited.
So
But
once a
here I
document
have
is not
annexed.
exhibited, they don't form part of the judicial proceedings. And a document first has to be
That is
exhibited.
why my prayer
There
has
that
to
your
be a
lordship
petition.
have the authority to examine this. So
No.
your
No.
leaflet may be, my lord, examined by this.
If you have any authority, you bring it. This will not help. I think this is not working here. Section 107 CPC Order 41 Rule 27. This is not working here. With this judgment, not working. You see the comments on the CPC 1908. Neither the issue frame nor evidence laid in trial court in respect to mixed question of fact and law. New plea raised before the Supreme Court not permissible on the ground at that the establishment of fact by evidence for decision is necessary. This is comment. Vasanta Vishwanathan VK. So this goes against you.
Yes. Yes, my lord. Yes, my lord, and we have not made prayer for remand also. Okay.
Even your lordship, I mean, even the order 41 rule 27 application will not be applicable in this case because the statute states that this additional evidence can be brought into record by the virtue of this provision when some new facts has been discovered, which was not in the cognizance of the petition plaintiff at the during the course of the trial, and because of some
No, it was
inadvertent,
not in the course of trial.
it was
But
there.
during appellate stage,
Yes.
they have come to know.
No, that was during those pamphlets and all were they were part of proceedings. Those pamphlets which they are saying they were not exhibited, they were there right from the beginning. They had provided as a list of documents
Pamphlet
also.
they have submitted, but
Submitted, not
not
exhibited. So these are already old documents.
And her reinstatement and all these orders were passed during pendency of that suit.
During pendency of the
Yes,
suit.
my lord, because the appellant had filed
So
writ
then
petition
you have
for
no
this.
under order 27, order 41 rule 27. Grounds which may be taken in the appeal. The appellant shall not accept by the leave of the court urged to be heard in support of any ground of objection and set forth in the memorandum of appeal. But the appellate court in deciding the appeal shall not be confined to the grounds of objection set forth in the memorandum of appeal or taken by the leave of the court under this rule. Order 41 rule 27, no?
Yes.
Should I start dictation or should I give you one more adjournment to substantiate your case?
One more adjournment may be given, so I'll try my best what to do.
Okay. You come prepared under 107.
Actually, your lordship, if you look at the prayer,
Hmm.
even in the prayer portion of the first appeal, page number 40,
There's no prayer.
there is no mention regarding remand back then. Now, at the time of hearing,
No, but a court can remand back if court wants.
yes, sir.
Court can remand back.
But
Court
you,
wants.
but your lordship, they have not exhibited that.
That is why I'm asking, should I give a date or should I start with the dictation?
Up to your lordship.
Okay, both come prepared then. One more date,
Hmm.
both come prepared. you have seen,
Hmm.
you have seen she has brought up something which I'm not accepting because there's no prayer. Order 10, section 107, order 41, rule 27 on these two. And then it can be remanded without any prayer. Can be remanded without prayer, but at this stage, without whether can be remanded, that can be remanded, that I know. Without making any prayer, it can be remanded.
Your Lordship will kindly look into the fact that due diligence had been taken at that point of time if the documents were available, because those were already part of the proceedings at that point of time. They were not the documents which were discovered later. Because the pamphlet
You
and all.
prepared that day you submit.
Yes, sir.
You have a ground. You submit. Those are relevant points.
Mm.
Those could have been adduced as additional evidence
That
also.
point of time.
And then when they were aware, they could have given a petition for order 107.
One
order
thing, my
40.
lord, by the time the order of this honorable court was passed and the appeal was heard and appeal was, my lord, she was reinstated, her counsel, my lord, expired, my lord. That she informed me the other day when I asked her. So she could not communicate properly.
Let's see.
Yeah.
We'll hear you finally, and then they will give the dictation. All free data dictation to deliver powers. A Friday. A decision or a Friday?
On 13th, your lordship.
The free assembly. Friday. Deliver power. Part argument submitted by learned counsel Miss S.B. Chaudhary and learned counsel Mr. Your name?
G.R. Datta.
Huh?
G.R. Datta.
G.R.